The Supreme Court is back in session in just a few weeks, and there are some extremely important Second Amendment cases sitting in front of them. One of the biggest is Duncan v. Bonta, which in my view is the strongest magazine ban challenge we have ever had lined up for the court. A lot of you have asked the same thing if the justices decide not to take Duncan. What happens next in California? I am going to answer that. But first, we need to rewind and look at the road here that led. Real quick before we get started, if you are watching this and you have not subscribed yet, consider hitting that subscribe button. It is free. It only takes a second, and it really helps keep this conversation alive. It tells the powers that be that people want to see content like this, and it lets more of you find these updates when it matters. So thank you to everyone who has stuck around, and thank you to everyone who shares these videos. Now, let us dig into the case and the history that shaped it, because context always drives understanding. Here is the situation. Duncan v. Bonta has been around for a long time, closing in on a decade now. The case was filed in 2017, and at that time it was called Duncan v. Becerra, because that was the Attorney General then. The lawsuit grew directly out of California Proposition 63, the ballot measure voters approved, and many people nicknamed Gunmageddon. Prop 63 bundled new restrictions together, and one headline piece was a hard cap on so-called large-capacity magazines, meaning anything over 10 rounds. Voters passed it, lawsuits followed BTO, and Duncan became the tip of the spear. Duncan began in federal district court with Judge Roger T. Benitez, who a lot of folks in California call Saint Benitez, and that is where Freedom Week was born. Because of his ruling, for 1 week, people in the state could lawfully buy whatever capacity magazines they wanted. To this day, those Freedom Week magazines remain legal to own and possess. That short window is not just trivia. It shows how court decisions affect real lives. It is the gear you carry, the magazines in your range bag, and the difference between being free and being punished for ordinary hardware. From there, the case did the usual ride up the escalator. It went to the Ninth Circuit. It even made its way to the Supreme Court once, and then the ground shifted under everyone's feet. The Bruin decision landed and told lower courts to judge modern restrictions by text, history, and tradition instead of interest balancing. After Bruin, the case was kicked back to the Ninth, which kicked it back to Judge Benitez to apply the new standard. He did exactly that, and again found that California's magazine ban violated the Constitution under the proper test, as the law demands. Then the file went back north and the Ninth Circuit changed course. The court ultimately said the ban could stand. That is the decision that produced the famous video dissent from Judge Van Dyke, where he laid out how ridiculous it was to prop up California's prohibition while acting like the Second Amendment does not mean what it says. You could feel the frustration in that dissent, because it captured what many people inside and far beyond California feel: courts bend over backward to protect every other right. But when it comes to keeping and bearing arms, everything becomes negotiable. Here is where we are now. The case is baked, the record is built, and the arguments are sharp. This is exactly the posture you want when you ask the highest court to step in and settle a national question. Are magazines over 10 rounds protected arms, or are they mere accessories a state can outlaw at will? For anyone new to this, lawsuits start in district court, move to the Court of Appeals, and the Supreme Court decides which to hear. Most petitions are denied. With that map in mind, we can talk about what a denial would trigger. The Supreme Court is unpredictable when it comes to the Second Amendment, and that is something people have learned the hard way. A lot of petitions have been filed, and only a handful have ever been granted. That is why Duncan v. Bonta stands out. To understand why, let's look at how the court usually handles these cases and why optimism should be balanced with realism. Historically, the justices deny most petitions without explanation. The process is called certiorari, and it takes 4 of the 9 justices to vote yes in order to hear a case. Thousands of petitions pour in every year, and only a fraction get through that narrow gate. Second Amendment petitions often struggle at that stage. Even solid challenges like Snope and Ocean State were discussed at conferences more than a dozen times before the court simply said no. Those denials were frustrating because they left lower court rulings intact, rulings that chipped away at fundamental rights. The lesson is that we cannot assume Duncan will automatically be different, even though it is strong. The difference now is the Bruin precedent. In 2022, the Supreme Court clarified that courts must evaluate gun laws under text, history, and tradition. No more weighing government interests against individual rights. No more so-called balancing tests. That changed the landscape entirely. Duncan was sent back down under that new standard. Benitez applied it, and still the Ninth Circuit insisted the ban could stay. That direct clash between the Supreme Court standard and the Ninth Circuit's approach is what makes Duncan ripe for review. If there is any Second Amendment case that deserves the court's attention, it is this one, because it exposes how some lower courts resist even clear instructions from above. That tension alone could motivate the justices to step in. But again, hope has to be tempered with the fact that the court is never obligated to accept. Certiorari is discretionary, not guaranteed. So what happens if the justices say no? That is the question everyone keeps asking, and it matters for anyone who owns standard capacity magazines in California. The simple answer is that a denial would solidify the Ninth Circuit's ruling, and from there the procedural gears start turning. The case goes back down, and the Ninth Circuit issues what is called a mandate. That mandate is the official order that enforces the judgment, confirming that California's ban is valid under the Constitution. Once the mandate is in place, the law is active again with full force. The timeline is not perfectly predictable. It could take 2 weeks. It could take 3, maybe longer. Sometimes courts move faster, sometimes slower. There is a slim chance of a grace period, where the court might give people a little time to comply. But history suggests that is unlikely. Once the mandate drops, magazines over 10 rounds become illegal to possess under state law. That does not just apply to new purchases. It sweeps in every magazine, whether it was bought decades ago, during the old grandfather period, or during Freedom Week in 2019. All of them would be covered. The law gives no compensation for property taken away. Prop 63 required magazines to be removed, destroyed, or turned over to an FFL, but it never offered reimbursement. That is why so many people argue that the law does not just violate the Second Amendment, it also collides with the Fifth Amendment's takings clause. In plain terms, the Constitution says the government cannot take private property for public use without just compensation. California's scheme ignores that safeguard entirely. People spent their money in good faith, only to face a demand to surrender property with no refund. That is why this issue cuts deeper than just one amendment. The practical outcome would be chaos. Tens or even hundreds of thousands of law-abiding citizens would suddenly be in violation overnight. Some would scramble to comply, hauling magazines to police stations or gun shops. Others would quietly store them away. Still others would simply refuse. That is where the dark humor about boating accidents comes in, the joke people tell about losing gear to avoid confiscation. And beyond the humor lies a serious possibility: mass civil disobedience. When laws criminalize common tools owned by ordinary people, resistance is almost inevitable. California may try to enforce compliance, but enforcement on that scale is nearly impossible without turning neighbor against neighbor. That is the weight behind the question. A denial at the Supreme Court does not just end a case. It unleashes immediate consequences for real people, erases years of investment, and pushes constitutional boundaries that were supposed to be settled. It is not an exaggeration to say the stakes are enormous. California has always been at the center of these battles, but it is far from alone. If the Supreme Court denies Duncan, the effect will ripple far beyond state borders. Other states already enforce their own versions of magazine bans. New York and New Jersey have strict limits. Hawaii and Oregon adopted similar laws. Washington recently expanded restrictions as well. Colorado set its ceiling at 15 rounds rather than 10. But the principle is the same. The government dictates how much ammunition you can legally use. Each state presents the rule as a matter of public safety. But when one federal circuit upholds such a ban and the Supreme Court refuses review, other states are encouraged to follow. That is why Duncan matters nationwide. It is not just about one law in California. It is about whether the highest court allows a patchwork of restrictions to spread unchecked. This broader picture highlights the constitutional problem. The Second Amendment is supposed to apply evenly across the country. You do not lose your right to free speech when you cross into another state, and the right to keep and bear arms should not vanish at a border either. Yet rights now look different depending on your zip code. California says 10, Colorado says 15, and some states impose no limit at all. That confusion is exactly what the Supreme Court exists to resolve. Its role is to unify the law,
making sure constitutional rights do not depend on geography. If Duncan is denied, the message is the opposite rights can shrink or grow depending on where you live, and the court is content to let that stand. That is why so many people are watching this case so closely.
It will show whether the court is willing to enforce its own precedent or leave Americans stuck with fractured interpretations. The stakes could not be higher. In California alone, hundreds of thousands would suddenly face criminal liability. Families who purchased equipment legally, even during Freedom Week, would be forced into impossible choices. Do they surrender property worth significant money without reimbursement, move it across state lines, hide it, and hope not to be discovered? None of these options are fair. Beyond financial loss, the deeper issue is liberty. Can the government reclassify common tools of self-defense as contraband and punish ordinary citizens for refusing to comply? This leads to the chilling effect. When people are afraid to exercise a constitutional right because the rules shift unpredictably, the right itself begins to erode. In practice, that means gun owners self-censor. Some avoid lawful activity out of fear the law will change again tomorrow. Others comply reluctantly. Still others resist silently. That atmosphere of doubt is not how rights should work. The Constitution was written to provide clear protection, not to leave people guessing about when they might become criminals. Such uncertainty undermines trust in the legal system and breeds resentment toward both lawmakers and courts. All of this circles back to the Supreme Court. The justices now have a chance to resolve the conflict, to affirm that the Second Amendment means what it says, and to strike down bans that contradict both text and history. If they decline, millions of Americans remain trapped in a maze of conflicting rules. Few cases are as clean and ready as Duncan, and few offer such a direct test of whether the court will enforce its own standards. The question is whether the justices will act. So, what is next if they say no? The outcome is stark. California's ban stands. Other states double down, and the Second Amendment loses ground across the country. What is next if they say yes? Then the showdown finally arrives after nearly a decade of litigation. The court will decide whether so-called large-capacity magazines are protected arms or mere accessories the government may erase with legislation. That ruling will not just settle Duncan. It will shape the future of gun rights nationwide for years to come. And that is why this case matters so deeply. Whatever the court chooses, the impact will reach beyond California. It will touch families, communities, and states across the map. That is why I'm urging you to stay tuned, stay aware, and keep paying attention. The decisions made in the coming months could reshape everything. Thank you for watching, and I will see you next time.